for high Gyamfi news. Mema Obibia Akwaba. Latest hot enkwa eramede bremo na ansana ensebni nyina bebano. So when you subscribe ya bomori ya se over subscribe na wa like video no give us a thumbs up na fi share ma wo fufro so na when you be here na wo ensemwa ekoso ewo Ghana memo afi yenhwe eye ensemwa abeto yepono so inti eye sankobo ya ekoso mama yenti.
Let me tell you something. You know how this world works. Because people want justice in this case, I've been given credible information that all this while in January, when we started saying that, look, if Ofori Atta is not coming, then let's take steps to do trial in absentia so that we can confiscate his properties, etc. And it wasn't done, they delayed. It turns out that in the interim, Ofori Atta is trying to get permanent residence in the US.
You got this information from where?
Oh, you know, this work we do, if I had to disclose all my sources would dry up.
You say it's credible.
Yes, credible. Yeah, but I have to keep citizen journalism. I have the right to keep them. So right now, the key thing is that, and that's why it's even irking me more. So as OSP was doing kukwasa, Ofori Atta, through one of his sons has applied for him to get permanent residence in the US.
From the special prosecutor. You remember earlier he had indicated, or the office had indicated, they're going to charge Ken Ofori Atta and others by the end of this month. The Office of Special Prosecutor has officially charged the former Finance Minister, Ayɛka Ofori Atta, and the Strategic Mobilization Limited and 6 others for corruption-related offenses. In all, there are 78 counts of corruption and corruption-related offenses. The other accused are Ernest Darko Akore, 67 years of age, chef de cabinet to Minister of Finance, or the former Minister of Finance, Emmanuel Kofi, 66, former Commissioner General of the Ghana Revenue Authority, Reverend Owusu, 64 years, former Commissioner General of the GRA. The rest are Isaac Krentil, 63 years, former Commissioner of the Customs Division of Ghana Revenue Authority, Kojo Kyeremanteng, 65. He is a member of Parliament. Yeah. And then also he's a former commissioner of the Customs Division of the GRA. Ivan Seduse, 62 years old, beneficial owner, CEO, and controlling mind of the accused company and the beneficiary company itself, Strategic Mobilization Limited, SML, formerly Strategic Mobilization Enhancement Limited. Now, if you recall, on October 31, President John Mahama ordered the immediate termination of all contracts with the SML following the completion of an investigation by the Office of the Special Prosecutor, and indicated that the move forms part of a commitment to accountability and transparency in the management of public resources. Here's what we do know, and let's clear this. After this became public, we got notice of Ken Ofori Atta being taken off, or we were not seeing his picture on the Interpol website, on the red notice. The special prosecutor has sought to explain why Ken Ofori Atta's picture and name is not on the Interpol red notice, or has been taken off or redacted, for the lack of better expression, from the Interpol's red notice database. He says there's some review that's going on. But is that standard practice, lawyer, from what you do know? That if there's a review going on of a sort, because there's some new information available to Interpol, they will take the person's name and details off and the wanted notice off while the review goes on. And afterwards, what? Put him back?
That's if the yes, show that he should be put back. So the context is that currently there is, let's call it legal proceedings at Interpol. So they have a unit responsible for this. So it's practically like a court on its own. So OSP, or let's say Ofori Atta against OSP. So you file, the Ofori Atta is complaining that there's no basis to have him on the Interpol red alert, blah, blah, blah. Then OSP says, no, there is. They say, okay, each of you file your case. They've done, then there are responses. So if you read the procedure, it's practical. There's going to be a decision. So judicial, well, okay, it's administrative, since it's not a court. Some administrative proceedings in there. So they'll go through each part to argue their case, present what evidence they have. Then at the end of the day, the committee would come to a decision on it. So if they come to a decision that, yes, Ofori Atta's name should be fully restored, it will be done. If they come to a decision that there is no basis, then his name will be taken up. So really, and when I say his name will be taken up, let me correct this, because OSP is very particular about it. It's not as if his name is totally off the system. As what it means that Rana is restricted. You and I can't see it as Ofori Atta. But the value is the same. Basic thing is that he's no longer a person that if any Interpol member saw today, they can arrest. That's the real point. Because once he remained on the list, and when we say Interpol, so Interpol is what? Police organizations around the world. So the countries that have joined, over 100, right? So that means that once he's on the red notice alert, it means that if he was found in Togo, they could arrest him. If he was found in the US, they could arrest him. So now with what has happened with this decision to restrict him, so it means that if they found him today, they will not arrest him. That's the most important thing.
I see.
Yes.
So if he is seen today,
yes,
to the extent that...
Yes. He's been removed, restricted. We are using effective communication. The key thing is, what is the effect of what has been done? The main effect is that he will not be arrested. So
if he's seen today?
Yes. So whether you call it removal or what do you call it, restriction, the key thing is that would he be arrested today if he's found? No. And now let's situate this. So it's not really about the Interpol red notice. So what it does is to like blacklisting. Okay, so it's something, there's some effect in a blacklisting. But if we look at what Ghanaians have been looking for, which is that he must come back to Ghana, that one is a long shot. Long shot because even if he's arrested today, he will not be automatically brought to Ghana today or tomorrow. No. You see the extradition that the Attorney General is working on, that is what has to be granted. You know, they will do it, send it to the U.S. government. Then the U.S. government will go through it, the Home Department, blah, blah, they'll look at it. Then they will go to court. So eventually there will be court proceedings in the U.S. because Ofori Atta will contest his return to Ghana, right? And so it's not today or tomorrow. And you see why every day I'm pained and I keep saying that. So the man who allowed Ofori Atta to escape, that's Kennedy Agyapong, has to leave the office immediately because he's fueling the suspicion that they colluded. Let me tell you something. You know how this world works. Because people want justice in this case, I've been given credible information that all this while in January, when we started saying that, look, if Ofori Atta is not coming, then let's take steps to do trial in absentia so that we can confiscate his properties, etc. And it wasn't done, they delayed. It turns out that in the interim, Ofori Atta is trying to get permanent residence in the U.S.
You got this information from where?
Oh, you know, this work we do, if I had to disclose all my sources would dry up.
You say it's credible.
Yes, credible. Yeah, but I have to keep citizen journalism. I have the right to keep them. Okay. So right now, the key thing is that, and that's why it's even irking me more. So as OSP was doing kukwasa, Ofori Atta through one of his sons has applied for him to get permanent residence in the U.S.
I see. And
so
this,
that
and this
complicates his return.
I see. This you are able to prove.
Sorry?
You're able to prove because this is from a credible source.
Yes.
So you have enough information to prove that indeed he has applied to get permanent.
Oh, no, they will release it. But I look at where the source is coming from. I believed it. And of course, if push comes to shove, we'll go into the U.S. system. That at least is there. This okay? We'll do a request, RTR request to the Homeland Security and the Home Department in the U.S. So the key thing is that as we're here from January, we started asking for trial in absentia. OSP came and were giving us ridiculous, ludicrous answers that no, you cannot do trial in absentia. 11 months only to do a U-turn. So then it fuels the suspicion. The analysts are like, oh, so were they denying trial in absentia so that it gives Ofori Atta enough opportunity to get permanent residence?
Because they're going to court on Monday.
Yes.
The fugitives, as has been described, they are not in the country, obviously. So the trial is going to go on.
Yes.
What's going to happen on Monday is they're going to hear them.
Yes, but the fact
that will be in the absence of Ken Ofori Atta.
Preliminary
Does that amount
matters.
to a trial in absentia?
Yes, the trial is, let's say this, before the trial in absentia will be done, Article 19, Clause 3 requires that the OSP will prove to the court that Ofori Atta has been notified, the very thing we have been talking about. As to how they do the notification, Monday will come, then we'll see. If they've done it, fine. But if they've not, then it means that for Ofori Atta and Asare, his chef de cabinet, or is it chief de cabinet, his PA, let's use the simple term, his PA, the trial for them will not go on if there is no proof, cogent proof that they've been notified. Because let's read 19 clause 3. It says that he has to be notified. So if the accused is notified of the trial and he doesn't come, then that's when the court will go on. But please, that technical term, well, in this case, I would say technical because it's not cheap. Notification, that's what OSP has to prove to the court. And this is what lawyer Tadiosori had been saying from day one. You know, Tadiosori was one of the first to say, let's do trial in absentia. In January, when this matter came, if you check the records, I think for me, in reading commentary on this matter, lawyer Tadiosori was the first to ask for trial in absentia. Then later, all of us joined. Me, initially, you know, we thought, oh, he would come. And, you know, but it turned out that at least some of us converted far earlier and joined Tadiosori in asking for trial in absentia. And OSP kept stonewalling, whilst Ofori Atta is taking steps to get better residence in the US so that his coming here will be more complex. And don't forget that he has huge investments in the US. Huge investment. And the American government will not lightly throw him under the bus. So you have to be very careful. This is a political decision. Look, at a point, after Kwabena Agyapong is left, later in our series to get justice, we may have to organize a demonstration to go to the US embassy and present a petition. That's what we have to do. We have to mobilize Ghanaians after Kwabena Agyapong is left, because that's the first point. We can't trust Kwabena Agyapong to do this work because he saw Ofori Atta leave. He saw the letter. I'm happy Professor Agyapong is here. Please, Mr. Okansi, when he gets to this, let him explain the political theory of the state. How, when I keep saying, when I quote the constitutional provisions and I show that under the constitution, Kwabena Agyapong had a mandatory duty to inform Ghanaians once he saw Ofori Atta was leaving, and he alleges that the other.
So you expect that you address a press conference?
Exactly. So I want Professor Agyapong from the governance experts to come. And also, no, there's also governance. Let all the governance experts weigh in. Then we see that it's a serious constitutional matter.
You see,
serious
in this instance, I'll come to you.
Okay.
I'm sorry. But his lawyers are saying that he has not been formally served.
So that's why we said on Monday we'll hear that. So let me just read it. That's why I said cogent evidence how he's been served. 19.3, just for those who want to hear the constitutional words, then we'll move on. It says, the trial of a person charged with a criminal offense shall take place in his presence unless A, he refuses to appear before the court for the trial to be conducted in his presence after he has been duly notified of the trial. So after he has been duly notified. So Monday we'll see, maybe if OSP did it and has not told us yet, well, Monday we'll see. You see, but the key point we're making is that the extradition itself, look, it's not a joke. It's a whole process. That's how come I said after we get Kwabena Agyapong out, we'll have to mobilize Ghanaians. Once the US government understands that citizens understand what's going on, that extradition is political, maybe it will help them to bring Ofori Atta. But if we leave it to TV analysis, you know, they also gauge public opinion. If a few experts come and sit here and say extradition, and lots of our citizens are not bothered, it won't happen today. But when we mass up a lawful demonstration quietly to the US embassy and present a petition that we want the American government to bring down Ofori Atta, it would help.
So that extradition process is where I reserve that for lawyer Christian Mamhesi because he's written quite extensively on it. So I'll come to you on it. But don't be Apiakobi.
Right. In fact, I'm a little worried about the whole process because I've heard of lawyers of Mr. Ofori Atta also writing to OSP and responses coming and publications thereof. I asked a question. Upon what information is the lawyers writing to the OSP? Is it the case that OSP has served Ofori Atta a process for which reason they are responding and even suggesting dates of his arrival and his interrogation? Is that the case? It's another big question we have to answer. If there was no such correspondence or information, lawyers will ordinarily not act without instructions. So the presumption is that Mr. Ofori Atta has knowledge of any such invitation and has instructed his lawyers to respond. Otherwise, the lawyers would not, out of the blue, just come out and respond. And your relationship with your client is not in perpetuity for you to say that once I hear that my client, you have mentioned my name, I write. No. In all situations, you must take instructions from your client, because when he is even your client on retainership basis, something new comes, you need to inform him and then take instructions in relation to that which would have come to the fore. So I'm worried. I don't understand why lawyers will respond if he has not been informed of anything. And the reduction from public view doesn't connote withdrawal of his name from the shadow of Interpol.
So
it says that it is only the public who cannot see.
But he's still
it is not by way of publication. But the request from OSP is still there, probably with his name and documents attached. But it is that for the purpose of Mr. Ofori Atta's complaint of service, they want to investigate how authentic the application is. And indeed, service does not connote hearing from the public. So if I'm coming here and you have sent me a process and you are talking about it even on your platform, that does not connote service. And indeed, for criminal proceedings of that nature, you must serve the person, not...
That is, that you must serve the person.
That person.
Physically.
The suspect, you must
him.
Serve him. Only to say that if you are not able to serve him personally, there are other means of service, genuine service, substituted service. You go to the courts and find the court's orders, and the court will order you how to effectively serve that person. Circumstances will determine. Again, non-service. When you don't serve a party, a process, you don't start anything. So I'm worried. Why will the Interpol place him on red alert when there is so probably evidence of non-service? So I'm also worried.
So that's why, because we talk about the availability of new information, a review process that's ongoing.
Right.
And reason why.
So I want to believe that Interpol was convinced of this primary requirement of service. That is why he was so advertised. If that is not the situation, then I'm worried about that informality. So,
but then again, does it mean, and this is what people said earlier, does it mean that if, for instance, if he is seen today, he cannot be arrested?
Yes, because from the records and from what the lawyer is saying, he has not been officially notified, means he has not been served. And what the lawyers are also saying is that if he has not been served, then he's not ready for any. And again, he says that he will return once he's officially notified. And I'm saying that the notification must be official. I mean, that is the requirement of the law. But when OSP also says that I saw him leave, I couldn't arrest him. OSP has police powers as per his law. Yeah. So OSP can arrest. So if OSP, yes, if OSP didn't arrest him, he has to explain why he didn't arrest him. And in any case, if OSP also wanted to formalize the arrest, he could have gone for absconding warrant, which would have been served to the border security agencies for them to even effect the arrest. So, complaining of inability to arrest, for me, it doesn't stand with me. He had all the powers and all the opportunities to effect the arrest. It was by his decision not to arrest that he was not arrested. So Ofori Atta didn't do anything by going through the process and getting out of the country. We cannot charge him. The person who was supposed to have done the thing also, if he decided not to do it, that he has the explanation.
Well, he's explained why. He said he didn't have the cooperation of the other state agencies.
But he himself didn't need any cooperation. He himself, if I'm suspected of having done something that requires my arrest, he himself is vested in enough powers. In fact, most of these laws, when they were crafted, I was part of the discussion. So even the Yoko boss and his deputy, they have powers of arrest under the Police Service Act. Because they have police powers. It is only the Gold Board that the power was limited to interrogation and searching. There was a reason to do that. So Gold Board has no power to arrest because Gold Board has not been vested with the totality of the police mandate. It is limited. If you go to Gold Board, as you see that there is limitation in the powers as given to them. Now, the confiscation of property. In fact, as Martin says, the Act allows for trial in absentia. But it cannot start when you have not done this basic requirement of service. So it is so important because once you have not served him formally, and I want to believe that the lawyers' reliance and insistence on formal service is coming out of their knowledge of not being served formally. And therefore, they are also picking information probably from the media, which I think is also not right on the side of... I would not write to OSP upon what I know from the media if my client has not been officially served. I would not do that. So I don't think that it was in anybody's business to attempt to respond to any invitations if you have not been served. And the media is not a proper place to serve an accused person or a suspect. Now, on the trial, once they are served properly, formally, and I have also discussed a service by substitution. So if for anything at all we can't find a person, please go for substitution and serve him. Once he is served formally, then the trial can commence in absentia. The only thing that, in fact, this one, I know that I had extensive debate with my leadership at the time when we were discussing this act, that we should have, the court should have opportunity to bring our orders of confiscation in the absence of the accused person. And my leadership at the time, they debated me thoroughly. I said, no, he shall be, he must be in the court. I said, look, if he steps out, and for any reason steps out, then you undermine the power of the court to confiscate. Somebody said, go and sit down. How long have you been here? And I said, oh, me, I'm a practical person. I'm a practicing lawyer. And I'm saying that if the accused person manages to step out, it becomes difficult. So all the work done will be costly. And this is in the law now. You need his presence in court for the court to be able to confiscate. It is in the law. You go check it.
That's why
you go check it.
Let me see.
Because there was extensive debate on this, because I was insisting that let the court have the power to pronounce it even in your absence. But we succumb to the seniority power.
No, but when it's trial in absentia, once it doesn't come, this one cannot override the constitutional provision.
I'm saying that
it cannot.
Look at confiscation of access in absentia. Look at it. It generated a lot of furore.
And so that will be bad. The judge will not be tied down. The judge will override
it. You understand? If the law says the courts are servants of legislation, so if the legislation is served on the court that allow Professor
The
Agyapong
court
to
does
go.
not have discretion.
The court doesn't have discretion,
Yeah.
but to allow Professor
Yeah.
Agyapong to go. So sometimes experiences in the legislature is important, but also as a junior's experience is also important. So this is where we are. We may come to a crossroad where the court probably, after a trial, may pronounce guilt or anything. I'm not suggesting that. That when it is so pronounced, then we go into how do we go for remedies as a state. And that is where we are going to probably encounter some of these difficulties.
I see loopholes. I was telling you. I to be outstanding. No, section 50.
Your attack should not go to the man OSP. It must go to the law as enacted by Parliament. And these are some of the amendments that could be recommended. But I am telling you from a practical, personal experience that it got me to. I will mention the name too.
Let's look at the section. Otherwise, it will create problem. Let me look at section 50.
I need to move on to
the conditions for the confiscation. And please, let's just make this small distinction. While the trial is going on, what we do is called freezing. So for the freezing, once they file the charges, OSP in itself can freeze for 14 days. But at the end of 14 days, the powers elapse. So he goes to court to get a court order to continue confirmation. So that's freezing. Yes, that's what I say. So now confiscation is when the person has lost, that the accused has been convicted. They want to. So the difference is that confiscation we take it permanently.
And even with freezing, upon time, a year or thereafter, it lapses.
Yeah,
so freezing is different from confiscation.
The Anti-Money Laundering Act we've amended, and the OSP one too is not tied down like that.
So I am saying that when it comes to confiscation, that's where we are going to.
So can we look at this? We say that.
But Martin, if you allow me to finish,
I think
you take your time to read. Now,
round it up for me.
Beyond confiscation, then we go into the extradition processes. And as Martin says, it's another process of its own that has to be initiated by the Attorney General from here, and then applications filed in the US. And the process will go to the very end upon determination. If the answer is extradite him, then the US government will send him. Martin said it's a political decision. It's not only political, it's political and legal. So the legal process will generate a decision, and it will be left with the political establishment to implement. So when we are able to secure the determination in the courts, then you are confronted with an implementation system which is also political.
Let's correct something. Before even they decide to go, it's like prosecution. They can say they won't even go. That's where the political element is huge. It's not after if the judge determines and they refuse, they will get trouble. So they may well decide not to go. They will assess the whole file and say they won't go to court at all.
You see, the whole process will start from the government prosecutor in the US.
Exactly. So you say I will go.
This same concept of nolli prosequa is also applicable to them. They formulated it. So if the state of the United States says that, well, this case is not prosecutable and therefore I won't prosecute, that's another challenge we will face. But if the Attorney General in the United States agrees that we must commence an action, it's an action by the state. And therefore we go through the whole process. And when you finish, the implementation also goes back to politics. So it is not an easy direction to take. But it is also worth taking. For nothing at all, it provides avenue for learning.
Indeed. Well, Professor Agyapong, you see, because this matter has both the legal and the governance side of things.
Let me do one thing. Just 1 second. I've seen
seconds.
A practical case, a trial in absentia. The guy went. After that, they confiscated. The properties were just sold recently. Currently, we are chasing for the certificate of purchase. The guy ran away. The court finished and confiscated.
It depends on.
And they've sold the property.
But I'm telling you that if you check the law,
thank you very much.
He must be in the court.
You have different positions on this. The OSP has been clear on why it was unable to do what two lawyers are asking he should have done. And to the effect, 78 charges of corruption and corruption-related offenses have been slapped on Ken Ofori Atta and then also some 6 other persons, all in this matter that the OSP is investigating. He's still out of the country, by the way. His lawyers state he has not been formally served. Could anything have been done differently?
You see, Alfred, I am a bit worried listening to Martin and some other lawyers. It appears it's going to be a very Herculean task to bring Mr. Ken Ofori Atta to Ghana to stand trial in person, looking at the processes that would have to be resorted to.
Yes.
It's going to be very laborious. It's going to be very difficult because don't forget, he also has lawyers. And so they will be fighting what the state would, the measures and the efforts that the state will be putting in place. And that is why I believe, Martin, you've done well. When we started doing public discourse in media, you were not part, but you've come, I think you've carved a niche for yourself. I think I like the argument, the bits that you brought in, that then the OSP should have, at a point in time when he realized that he was helpless. I mean, he himself said he was helpless. I called NIB, they were not minding me. I called this one, they won't pick my calls and all that. So I'm saying, maybe, you see, he should have prevented, first of all, he should have prevented the flight or exit of Ken Ofori Atta. Oftentimes, when people are given mandates, okay, they settle in, and if you don't really sit down to read about your own mandate, there are certain things you may not be aware of. And so I see you, I look at my act, and I know what I'm supposed to do. I don't know whether the OSP didn't know that they have the power to arrest. I don't know. I said, I don't know whether they didn't know. And the other bit is that, well, so that's what I'm saying, that you have to socialize yourself effectively in your own act. Okay, because
if you say that you don't know your own act, then you don't qualify to be that.
No, but so then what was the point in coming to say that I called these agencies to come and help, and they all, let me down? If you knew that you yourself had the power to arrest. The second bit, is that
they had opportunity to also seek absconding warrant from the court.
Well,
and others will do his work for him.
The second
you don't arrest people by your mouth.
Yeah. The second bit is that, you see, we oftentimes have tended to believe that when it comes to arrest, it's always about, it's a function of the security agencies. Okay? This is what is ingrained heavily and deeply in our psyche as a people. But dear Ghanaians, there's something we call citizen arrest.
That's it.
Okay, we are the ultimate repository of the powers of the land that are exercised by appointees. Let me tell you a story. One day I had gone to a funeral in a village, and I saw somebody using a government vehicle to carry a casket. I stopped them. I told them that you have no right to do that.
A government vehicle?
A government vehicle. I don't drive government vehicle to social events. I want to use my own car. Government vehicles are for government work. But I saw somebody using a state vehicle to carry a casket.
A casket?
Said, yes. Stop. We stopped them. And said, who are you? I said, I'm nobody. But you can't do this. And I exercised that, I mobilized people to appreciate that it is our taxes that are used to buy fuel in this car that is being abused. And so they joined me. We made sure that they got the casket off the vehicle. I said, where do you, I don't want to give, but we were able to prevent that. So my point is, at that point in time, when the OSP saw that he was helpless, and maybe they didn't also appreciate their own powers that they have to arrest. What prevented them from, these days, every now and then, OSP is holding press conference. So why didn't they organize a press conference to tell us, fellow Ghanaians, we wanted to do X, Y, Z. We are calling ABC, they are not minding us. And so because of that, we are aware that the
How about the absconding warrant?
Well,
from the court.
So that the good people of Ghana would have appreciated what you were going through. In that case, the OSP would have escaped the current Martin Kweku blame on him that you knew and you are sanctioned, you looked on and then you sanctioned the exit of the man. And so I think that it's a difficult situation. It appears that the fight against corruption through the laid down legal processes is always going to be slow. But our own attitude as officials who are mandated and given the power to do these things must also not compound the delays and the challenges and the problems. So look, somebody is telling me that if you don't take it, we may go through the entire tenure of this administration and the man will still not be here. Because don't forget that he's also smart and resourceful to all manner of legal gymnastics, just to be sure. Well, it may not be time bound, but the point is, you strike when the iron is hot. And every Ghanaian, you see, I'm telling you, the survival and stability of our fourth Republican democratic practice is to a large extent also contingent on the kinds of things that are done by this administration in fighting and in addressing corruption. Absolutely. If it becomes business as usual and we perpetuate the cliche that Ubiabasa, it will be difficult because then people would want to take things into their own hands. And so it is important that examples are set. It is important that the right things are done. And like I said, agencies of state that are given the task and mandate to handle some of these things must also sit up and they must be up and doing. It appears that in our part of the world, anytime people are given appointment, they go to perpetuate or do the status quo. Nobody goes in there with a psyche of, okay, what can I do to challenge and to question? So look at what happened. You are going to recruit soldiers, and the status quo has been that everybody should be crowded and we should all go in. I mean, when you know that best practices elsewhere, people are able to even apply online and they do things to decongest. You know that unemployment is a serious issue in our part of the world. Mm-hmm. And so if you say that there is an avenue for employment and people must go, there will be stampede. And so what happened to those who were in charge? Why didn't they say, well, this is how we've done it, but today or in our time, we want to challenge the status quo and do something different? And so I'm saying that as we all get the opportunity to serve, the idea of how was it done yesterday must be challenged. Yeah. We should also have innovative...
a justification for the change.
For the change. We should also have an innovative ways of working within the confines of the law, but in a manner that challenges the status quo. Yeah. Let us begin to let citizens know that we are appointees and duty bearers. Even though you may be answerable to your appointing authority, you are ultimately also answerable to the ordinary citizenry whose powers are being exercised by you. Mm-hmm. And so the citizens have got a right to ask questions. They've got the right to demand accountability. Mm-hmm. And when we think that we are at our wits' end, when we think that we are facing a lot of frustration, I'm telling you, the most powerful force within the body politic is the citizenry. And so I was thinking that it would have been better, OSP would have escaped some of these blames or accusations.
Article 1, Article 35.
That's the difference between a lawyer and a non-lawyer.
Oh no, let Rob do that.
Sovereignty resides with the people.
Yeah, it's also political.
Yes. Sovereignty resides with the people, and so I think that some way, somehow, in the course of time, the OSP must come apologize to the people.
Apologize, he should leave.
So let me bring in.
There are currently 15 petitions for his removal.
Okay,
that's why
let me bring
online.
Okay,
15 petitions. But
I want. No, 1 minute. I'll come to you.
And the basis for my calling
to make the point, and then so that
no, I'm just explain the basis for my call. The basis for my call is the fact that his explanation that he called some security agencies and they let him down, for me, is only an excuse. He could have informed the good people of Ghana and would have known what to do.
Okay, Dr. Zato, just on this, especially because of what's going to be happening on Monday, that yes, the OSP is going to court, but then Ken Ofori Atta and one other are still out of the jurisdiction. His lawyers say that he has not been formally served. And this is coming at a time when the OSP itself is also facing the criticism of what he could, or the office could have done to prevent Ken Ofori Atta from leaving office. I mean, the coming days pregnant, or leaving the country, I beg your pardon, the coming days pregnant with what to expect. But could anything have been done differently?
Thank you very much for this opportunity. I want to start by stating clearly that I believe that the OSP has become, that office, that whole institution has become a relic, and that it has outlived its usefulness. It is now a big drain on the finances of this country, and I believe that if I had the power, that whole office should be shut down to Kluda and then Kluda. It's no more fit for purpose.
How do you mean?
I want to state that because if you look at, just do a very simple value for money analysis, that if you look at the amount of money this country has spent on the OSP and the expected return on investment, I don't think we've gotten it. If you look at the amount of money retrieved, the amount of people prosecuted and put jail, it is not a good investment for this country. That money could have been used to improve the Tumu town roads. That money could have been used to improve the Wire Big Push Tumu Chuchulega road. That money could have been used to do other better things. So that's my number one thing. Two, the charges that the OSP has filed is a Hail Mary throw.
What do you mean?
The overall objective of those charges is to get some powerful voices calling for his removal off his back. Yeah. There are powerful forces whose voices are heard on the corridors of power in the Jubilee House. There are powerful voices who, when they speak, people in authority listen. This charge sheet is just an attempt to throw something at the wolves, to throw something at the hawks, so that they will appease themselves and then they will let you go. And that's why I personally think that no, that is not the way to go. It's a Hail Mary through the objective to save his ass. And I don't think it shouldn't work. I would draw it. I would draw it. Sorry, I would draw it. Not his job. That is what I believe. Thirdly, you see, there was a plan, if you ask me. I think that there was a plan, there was a theory out there. The ultimate objective was bring Ken Ofori Atta down, dehumanize him, disgrace him, put him in jail, and reduce him to a non-entity. I think that was the original plan. That was the objective. Show him where power lies, dehumanize him, bring him down, put him in jail, and drag him down there to tell people that I've brought this mighty, I've brought the whole mighty Ken Ofori Atta down. But once that wasn't happening, I believe that the office went into kind of panic mode. Once that happening, it ceased to be a legal problem now. It became a political process. It became a political process, therefore, because you now think that the political leaders, that the people who are entering the politics, now wanted to do. This issue was being discussed in Parliament. Anything going to discuss in Parliament is political partisan. This issue has now taken very entrenched political positions. And that's why I believe that when the OSP felt that he could not have that grand prize, he could not have Ken as that sacrificial lamb of the powerful men that he has brought to justice in handcuffs, dragged around on the streets of Accra to court. That was when the panic set in. And for me, when you then put all this together, you then begin to ask yourselves, is this OSP office worth its salt? Should we continue to have that office there? It doesn't. Because look, we sat here, and even me, Martin from the last I was saying that, can you serve the person by whatever it is? Can you call it? Look, we are sitting here. The United Nations sometimes conducts its business online. Yeah. Huge multinational companies whose money or resources are powerful than this country have transacted and concluded businesses online. Powerful people have done that. The President of the United States has signed laws and bills through technology. So I ask the question, one, couldn't they have done a conference call and interviewed Ken? Couldn't they have done that? Agreed. They could have done that. Two, couldn't they have sent 3, 4, 5, even to the United States? Okay, you said you are not feeling well. And they would have gone with his lawyers, sit down in a room, like civilized people, discuss these things, and then explain these things and things. Couldn't they have done? They could have done that. couldn't you have spoken to the people at the Ghana embassy in the United States to facilitate the process where if you want, you can now meet in the Ghana High Commission, which is considered Ghana's land, where I think the laws of Ghana kick in and you do that. Because by the principles of diplomacy and international relations, the land and the soil and the office of the Ghana Armed Force, Ghana High Commission or embassy is still considered Ghana's land. You could have done that. In other words, there were a number of alternative measures, alternative approaches, alternative solutions to still speak to him, to still get the answers or lack of thereof, and to engage in these things without necessarily putting us through all this hula baloo of habeas corpus, or is it habeas corpus or whatever it is, of trying to get him here. You could have avoided this charade. You could have avoided this whole drama. But to choose the drama, to choose to go for this, it means that there were other motives.
I see.
Other than purely trying to get justice. And that is why I believe that office is no more fit for purpose.
Well, I just want to ask Martin something. Martin, 1 minute. Let us also face it. I mean, the man is in the middle of an action, doing something. Beyond, I mean, some of you asking that he be kicked out. Okay. Isn't it possible for us to use some of these criticisms and contrary views we are expressing to strengthen what he's doing? Because my view is, you want him out, but the next time you are bringing in another person to come and start all over again.
Oh, there are
and
officers under him. There is a director of prosecution, Isidore. There is a deputy OSP, a deputy Cynthia. What's her surname? Cynthia Lamte.
I see.
A deputy. Cynthia Lamte is even far senior. I'm coming. We are coming. Cynthia Lamte is far senior to Kisi Ejabin at the back. Kisi Ejabin is a baby to Cynthia Lamte.
Christian Esma must be sitting for a while. Let me bring him.
So there are people.
Is it from your view, there's 78 charges, Dr. Zato talks about it being a fishing expedition in his view. But reading through it, would you say the OSP, having taken this period to do the investigation, has a sure path from Monday going forward to demand accountability for us all?
It will be unethical on my part as a lawyer to run him down in respect of the 78 charges. But I believe that what I can say to that is that he's going to have a tall order to prove all of that, because in criminal jurisprudence, it is required of prosecution to prove his case. And the burden that is affixed to the prosecution is very, very high. So to have 78 of this and to go through the mensura to prove the mensura and the atuzria. So when we see the mensura, we talk about the blameworthiness of the mind, the intention to commit an offense. And then the atuzrios is the acts, the circumstantial steps taken, the circumstantial evidence, and which also includes the acts taken by an accused person. So it is the mensura plus the atuzrios that is equal to a criminal offense. And in certain situations,
conviction.
Yeah, conviction. And in certain situations, one could be dispensed of in situations like street liability and all of that. You see, so he's definitely going to have a very big or a tall order to deal with, to scale over, because to deal with all of them, unless, of course, I mean, he knows what he has under his sleeve in terms of investigations, which culminates into evidence gathered, which would help him convict the case that he has. Other than that, it would just be a walk in the park, as in he will not achieve what he is seeking out to. And we must also be minded that when it comes to criminality, the slightest doubt that is cast, the accused will have his day, and the prosecution's case fails. So it is much work for the prosecution to do, and it is also for the defense lawyers just to cast doubts in it, because 78 is definitely a tall order. And like I said, as a practicing lawyer, I will not sit on such a platform to say that they are needless or it's probably a poor job done, or to say that he's just put up something to represent something. I cannot say that.
Okay, obviously, and that's not the path I want to take you. But let's stay, because this process of extradition, I know you think quite extensively on.
Yeah.
How long is it going to take? That is because the option of the OSP is to go on this path.
Yes.
And not a trial in absentia.
I remember when this whole extradition thing started, I had made a lot of pronouncements on it. I mean, I'd mentioned that it is never an easy journey, because for extradition to happen, it first starts, I mean, Ghana, we have the enabling laws, which is the Extradition Act, Act 22. And it deals with the fact that there must be a request for surrender. Now, when the request for surrender of the fugitive, so in this situation, Mr. Ofori Atta is the alleged fugitive. Now, after that is done, then it follows with the minister's order. And the minister's order goes to the district court for the warrant of arrest. Now, when that is done, we also have then it follows through with the apprehension. Then there will be a hearing. Now, that's where the problem is going to be. When the hearing also affords that particular person the opportunity to say that I don't want to be extradited to that particular country. So in this place, Mr. Ofori Atta would object in the US that he would not want to come to Ghana. And it is a whole trial that is going to happen. Should he be successful, then the US government would bring him down. But if it is not, then the answer is obvious. Also, key to note is that there must be what we call dual criminal offense, or extraditable offense, which is the offense that we are claiming he has committed. It should be that which has been listed under the offenses under the extradition laws, which both affect the US and Ghana. And when that is upheld, then the extradition process will also go through. We must also be minded that there are some restrictions which comes to it. The first one is just what I have said. If it is not an extraditable offense, then obviously US or during the trial to be objected, it will be one of the grounds that his lawyers would raise. On the other hand, too, the issue of political sentiments comes in. If it is a matter of political tracking, as in he's a political target, for which reason this particular action is mounted against them, the extradition laws indicate that becomes a restriction. And it would also be for his lawyers to amplify that if they so believe. I mean, they have room to play out their legal theory in terms of defense that they would want to put out. So these are the things that happen. And then after all of these intricacies that would happen at the trial, then we'll follow what we call the surrender. The surrender, basically, the namesake, the state of US will now have to give Mr. Ofori Atta to Ghana that, I mean, having gone through the trial, we are convicted in our minds that Mr. Ofori Atta is free. I mean, is free from all legal hurdles that would hold him down in the US to face the criminal trial or action that is being brought against him in Ghana. And that would be it. Also, be minded that if the surrender is issued and the state US holds Mr. Ofori Atta, that's it theoretically, I mean, in legal theory, is held for more than 2 months. The state of the US would have to leave Mr. Ofori Atta as a free man. So it basically means that it puts a time limit on the person who is so declared to be as surrendered to the receiving state to immediately put processes in place to extradite him to the receiving state, so that that person would not be left off the hook. So I mean, basically, in a nutshell, this complements the procedures when it comes to extradition laws.
A very important information.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.